This is CR 19890126318A. Please announce your presence.
Vincent Bordino on behalf of the state, Your Honor.
Good afternoon, Your Honor. Michael Kimmer and Lori Huebl on behalf of Debra Milke, who is present in the courtroom at this time.
All right. I have several things I'd like to discuss with you all today.
Your Honor, you asked me to be here, so I'm here.
Okay. All right. Please take a seat. First, I'd like to address the information that was provided to me from the state. Let me just get to that page. All right, I want to address the notice of letter from the U.S. Attorney's Office. I did read the filing from the state, and I don't want to belabor this point because I want to move on from this incident, but I do find the explanation to be surprising, and the only comment I will have to offer about this point is that if the information is relevant enough for the press, the media, then it is relevant enough for me. So in the future, if Mr. Montgomery wants to disclose any information to the media that he finds pertinent, I would like to know in advance what that information is. Because after all, we're not trying this case in the media, we're trying this case to me. And since I'm the person that has to decide whether Detective Saldate is going to be able to invoke the Fifth Amendment, that is relevant information for me to decide. So, but I want to move past that. Okay. Now, the next thing I want to address is the last day issue. I know that the last time you were all in front of me, it was my mistaken belief that we had 2 years, but upon rereading Rule 8, I believe that it's really still October 7th. And I think that we can come to an agreement, though, as to setting of a last day. And I don't know if you all have thought about it in advance. Typically, a capital case takes about 2 years. The last time Ms. Milke was tried, the Ring case hasn't come down. I don't know how much mitigation information you've gathered. I don't know how much evidence is still available or needs to be retested. So I really need your help on this. When do you think would be a reasonable last day from your perspective?
Our office was content, Your Honor, with, and I apologize, we were under the mistaken belief that it would be the 2-year time frame. But, you know, somewhere between 1 and 2 years. I know defense counsel had indicated that they were fine with that extra time as well, and we have no objection. So we're happy to stipulate to whatever time frame they feel that they need.
Okay, all right, Mr. Kimmerer?
We were also wrong, too. We thought it was 2 years, and we went back and checked after we heard from the court, and it is October 7th is the present last day. Debra Milke certainly willing to waive time, and I would think within a year or 2 years, somewhere in between a year and a half, make that the last stage, somewhere in that area.
Okay, so if I just had to pick a date, I would pick the end of December 2014. That's to be about the 1.5 year mark.
But that sounds fine with me, Your Honor.
Is that okay with you?
It is. Could I, without knowing what's going to happen, obviously, I would imagine that if we were coming upon the last day, and we were prepared to start picking a jury in December of 2014, that it would be easier to do after the first of the year. So other than that's all I would have to offer.
Okay. How,
That actually makes sense when you get close to the Christmas like that. Probably after the first of the year would be a better date.
how about if I set the last day for February 27th? Would that be February 27, 2015?
That meets with our approval, Your Honor.
Do you want to, will your client waive time?
Yes, she has discussed this and she is willing to waive time.
Okay, last day, all right, February 27, 2015. Then working backwards, then I would like to set a trial date for how about February 2nd? That's a Monday.
That's fine with the state, Your Honor.
That's fine, Your Honor.
Okay, February the final trial management conference will then be, I will make that January 23rd, that's a Friday, to resolve. Now, working backwards from that, I need to set a hearing date for Detective Saldate. The way I was thinking of doing this is because he can or cannot invoke his right to against self-incrimination. But I don't even know if he is still wanting to do that or not. So I guess I'm asking his attorney if you could kind of update me.
Your Honor, my advice has not changed. I advise Mr. Saldate that he should take these, that there is a risk and he should assert his Fifth Amendment privilege. He has told me that he accepts that advice and will assert his Fifth privilege.
Okay, and so having known that, are you going to be filing a motion to me to say, no, he doesn't get that right?
I think what I intended, what I had already filed, Your Honor, with you, providing the exhibits that I did and asking the court for an opportunity to discuss those issues, I've already filed that. So, and that's what I intended it to be. The only other thing I would say to you, Judge, is, you know, in the spirit of trying to keep you informed, I've been told that we are awaiting a response from the Department of Justice in Washington, D.C. on some of these issues. I mean, I can tell you that I don't, and I guess I would like to have this set off for a reasonable period of time. We don't have a definitive date from them when they would respond, and in fact, if they will. They've told us they will, but we don't have a definitive date on what their position would be. So I guess I would just ask a reasonable amount of time to give us a chance to let them follow through with that.
Okay, here's my concern about this whole thing. I did have a chance to look, I haven't looked at all the exhibits because it was quite voluminous, but I did get to read what you filed. But basically what you filed is challenging the Ninth Circuit's finding about why they believe Detective Saldate lied in certain occasions and violated other people's constitutional rights. But it doesn't have a brief that tells me what the state of the law is on whether someone has the right to invoke. Just looking briefly at this, I understand the letter from the U.S. Attorney's Office is only from Arizona, but it says basically nothing to me. It referred me to a statute, which is the federal statute of limitations, and it says 6 years. But as I recall, Detective Saldate last testified in 2010, so I don't know how that interplays. So that's what I'm looking for, is some type of memo or brief that actually discusses why I should not allow him to invoke the Fifth, not just simply a documents that says the Ninth Circuit was wrong when they made these findings. Because I recognize that is your position, but that doesn't tell me what the state of the law is on whether someone can or cannot invoke the Fifth Amendment.
Okay, well, I will provide you with
Okay.
something in addition.
And I know I also read the defense's preliminary response to the state's September 13th memorandum, and it says in there that you were planning on filing something already. So just to keep us all on track, I'd like to set deadlines. And in my mind, I don't really see this as the defense's burden to tell me why they shouldn't, why Detective Saldate can't invoke. In my mind, I think this is the state's burden. And so I want the state to file a motion first and giving them time to respond, as well as Mr. Davis to respond. And I know you said you would like some time to do that. How does October 31st look to you? It'll give you a whole month and
Correct.
half.
Correct. The 10th of November.
Okay.
So if we're going to have a date set, I would prefer not during that time frame.
Okay, we can do that because you have to file your memorandum or your motion, and we'll call that the motion or memorandum regarding Detective Saldate and privilege. And that's October 31st. And then I'm going to give Mr. Davis and the defense, if they want to weigh in, some time as well. And I'm thinking enough time for you all. I know you are going to be gone in October, which is why I'm setting it in November. Is that still not going to be good for you?
Such a simple question, Your Honor. Give me 3 days is fine. So whenever you want to set it, it's okay with me.
Okay. How about from the defense perspective?
That time
I
is
can
fine.
shorten
We
it.
can do
if
it
you
before
want.
then, but that date is fine.
Okay. You think you can do it before then?
Yes?
Okay, well, good. Then we can do it before then, November 15th then. Do you think you'll want to do a reply?
Well, I think to some extent it'll depend on what, if anything, we receive from the Department of Justice.
And so I'm going to set an evidentiary hearing on this issue for Friday, December 6th at 1:30. And I expect to, and Mr. Bordino, when do you think you can have the response done on that motion to suppress?
I anticipate filing it today.
You're filing it today?
Yes.
Will you be wanting to file a reply?
Yes, we will, Your Honor.
Okay. So if he files, then the reply will be due October 18th.
End of October.
And then we'll set the evidentiary hearing on the suppression motion. That won't be done until after December 6th because I don't know if he's actually going to be able to.
We have a problem with the October 15th date because we have conflicts in our own schedules at that time. So we need that before then or after then? Probably after then.
Your Honor, I'd prefer to have that around toward the end of October because I'll be gone during the week or so before that, and I'll be working on our responsive memorandum to what the state filed.
That's fine. How about October 31st?
Yes, that would be
Okay.
perfect.
And so I would like to do the suppression motion. I don't know people's time frame, so I could either set this for the middle of December or beginning of January. I don't have a preference, so you guys will have to tell me. Would you prefer January or middle December?
I anticipate being in trial, so I guess I would prefer after the first of the year.
Yeah. We would prefer January, Your Honor.
Okay, so let's go for January 10th. That's also a Friday. well? Well, actually, I don't know how long this is going to take. Do you think an 8-hour day will be good enough, or do you think it'll take longer?
I would anticipate at least 3 days, Your Honor.
3 days? Well, in that case, then I'd like to back this up to January 13th and reserving that week. So the evidentiary hearing on the suppression motion will be January 13th, 2014 at 1:30 in the morning, and then on successive 1:30s until the end of the week. And that will be January 17th.
That's 1:30.
Well, it is, except what I can't remember now, and perhaps you can bring this up at the next judges meeting, is I have a trial date on the Martinez case.
Martinez case.
And I don't remember now whether I think it's the first part of January, but Judge Granville would know.
Could you tell me the first name? I know I think we have a couple of Martinez's.
It's Daniel.
Daniel, okay.
Yes.
I will verify your trial schedule, and if it's going to be a conflict, we'll reset. Issues you'd like me to address?
Nothing that I haven't already mentioned in any of the pleadings that I filed, so nothing to add today.
Okay. Mr. Kimmerer?
The only thing we would address, Your Honor, is that the state did submit this memorandum regarding witness invocation of the Fifth Amendment privilege, and we are prepared to file a response to that memorandum. I think it might be the easiest to get it before the court is doing it in a two-stage process. We can have the first part of our response probably due by
End of this week.
probably by the end of this week.
I don't see this as an urgent item because of the fact that this goes into play with the whether he can invoke, and so that hearing is.
And I understand that, Your Honor, except we thought we should probably address every one of the cases, and that's going to take us time, even though that kind of comes after the other issue.
Right.
So maybe in that case, we could ask for a longer period of time to respond to the whole thing. Would that be better working out from that standpoint?
Your Honor, I think just as a threshold issue, it's our position that none of those materials are available, and we've talked about this, just their ability to even collaterally attack all of that. And I just about have that part of our response ready. It's on the law, but we felt it would be prudent for us to go ahead and address all of their arguments with respect to all of the cases that are cited in the Ninth Circuit opinion, but that's going to take some time. So what I guess I would like to do is go ahead and file a response just on the law with respect to how the state can or cannot attack the Ninth Circuit findings, the 8 cases that the court relied on, and the law relating to that. So I can file that by the end of the week.
Okay.
I don't know if you want me to do that as a motion to preclude, or how you want me to do that.
It would probably be easier to term it something like a motion to preclude or a memorandum on the law of the case, or however you want me to consider
I'll do
it.
that, and then I'll just address the cases discussed in their appendix separately after I'm done with that.
Okay.
Thanks, Judge.
One last thing, Judge, if I may. I did mention in one of my pleadings that it seemed to me, you've at least twice said you don't want the case tried in the media. And, we concur with that, but as I indicated in the pleading, there have been several opportunities the defense has taken to comment about Detective Saldate. And we're asking the court to order there be no more public comment, consistent with your direction here today, and I think on another occasion.
Right. That's so. I think I've always mentioned that I'd rather try this in the courtroom, not out in the press, but go ahead.
My reaction, this is the pot calling the kettle black. The press conference was called by Bill Montgomery that started talking about the case and presenting everything, and we did respond to some of the things and I think under the Gentile case we have a right to respond, but certainly we don't want to try it in the press either. But the county attorney's office continually makes press releases every week forcing us to kind of respond to some of the false statements and misrepresentations they've been making. And it would be better if we did try it in the press, and it wasn't do this, but we have no control over the county attorney's office and their press releases. But we can't, I think we have the right to respond to it.
Right, how about if we just stop? I don't want to issue a gag order at this point, because I don't think that I have enough to say that you can't talk to the press. But you each are very seasoned lawyers, and you know what's right and what's wrong. And so I can only tell you that I do not want to see it tried in the media. And if it goes along further where I hear, and I don't always read the newspaper, so I'm not aware of everything that you're mentioning. So if I don't, what I would like to say is that both sides should act professional and refrain from making comments, because eventually we're going to have to impanel a jury, and it's going to be awfully hard to do that if it's already all aired out in public. We don't even know what evidence is going to be, or what is going to come in, what's not going to come in, who's available. I'm simply going to say that right now I'm not issuing a gag order, but if I continue to see this type of press conferences or interviews with the media that seems to be shaped more towards shaping public opinion rather than just responding to allegations, then I will consider issuing one of those upon a written motion by one side or the other. Okay? So I also want to set a status conference, because the next time you'll be in front of me will be on December 6th. And I don't know if without resolving the issue of whether Detective Saldate can invoke his privilege. And so I need some help from you all. Do you think you need another one before December 6th, or I could just leave it at December 6th, and if you have further issues, you can always call my court, and then I can set it. I don't want you to have to keep coming back either. That's the way I was planning on doing it.
Your Honor, we're fine with December 6th.
We are fine with that date too, but I should alert to the court, we will be filing another motion on a double jeopardy issue, which will need to be heard at some point in time. And I'm sure that can be worked into the schedule we're talking about.
Right.
That should probably be filed no later than the first part of next week.
Okay.
And there'll be a motion to dismiss on double jeopardy grounds.
Okay.
And Your Honor, since I'm in trial, although we're now off for about a week because the defense experts are not available again until the 30th. I'm going to need more than just the normal time to respond.
Okay.
In conjunction with the other things that I'm going to have to file in this case as well.
Right, right. And I know that, you in the past have been able to work out extensions of time. So I'm hoping that you'll extend the courtesy for him, because normally I do. So I would just ask you that if you are going to extend the courtesy of giving him a longer period of time, if you would just notify my court so I don't go ahead and start issuing orders thinking that nobody's going to respond. Okay? So other than that, I will see you all on October 6th. Not October 6th, December 6th. If I could also ask the defense team to stay behind, because I do have the order that you asked me to sign, and I will give it to you right now.
Well, thank you.